is the next logical step of that exercise. The recommendations, the deliberations have been culled into a white paper, which will be a reference point for us, for those who want those issues to be resolved, to be attended. Friends, without taking a lot of time, the ceremonial lighting of the lamp. Let me first introduce our guests. The Director General of Health Service, Government of India, Dr. Jagdish Prasad is there with us. We have Dr. Ved Prakash Mishra. He chairs the Academic Committee of the Medical Council of India. And we have two members of the National Consumer Commission. Dr. S.M. Kantikar, who is himself a doctor and a law graduate also, and Dr. B.C. Gupta. And before he says he is a PhD doctor and not a medical doctor, because every time he introduces himself, he is very particular in saying that I am not a medical doctor. So before he says, I am introducing him as a PhD doctor. As far as doctor friends are concerned, they may not be knowing. Members means these two dignitaries are judges of the National Consumer Commission, the apex body which decides nearly 99% of the cases against doctors. So friends, with that introduction, I request the dignitaries to kindly light the lamp. Will now request Dr. Jagdish Prasad to kindly it's a ceremonial function, so please sir, could you just hold the stand and hold it up? Yeah. Please, 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 please. Thanks. The white paper culls the recommendations as also the concerns of all stakeholders in the healthcare, though in this national convention we did discuss on only 5 issues, and there were 3 breakaway sessions on hospitals, intensivists and critical care. But the recommendations are there. There has been a small change in program. The Honorable Chief Guest, Dr. Jagdish Prasad, has to leave a bit early. You are there till 8. Oh, okay. I was told that you have to leave at 7:30. I'm sorry. Till 8. That's great. So, sir, we have the keynote speakers of various joint sessions that were conducted there, and very briefly they will speak on the issues that were discussed there in Mumbai and are a part of this white paper. I'll first call Dr. Atul Kumar Shah, who will speak on the first issue that we took that day, providing free treatment to acid attack victims. Yeah, please.
Dignitaries on the dais and off the dais. A full day activity which took place in Mumbai is bearing the fruits, and of the several topics that were discussed, the topic which was part of a main session was about a recent judgment in the case of Lakshmi versus Union of India regarding the treatment of acid attack victims. It was interesting to note, and all those legal stalwarts here would know, that the recent amendment in the criminal clauses has already told the entire nation through these amendments about treating the victims of acid attacks and victims of various types of rapes to be treated free. However, it is little difficult to understand why an additional and a special judgment came in Lakshmi versus India. As a medical graduate and as a person who is registered under the Indian Medical Council Act, all the doctors are under the huge umbrella of Indian Medical Council Act, and one of the clause clearly says that the doctors have a privilege to recover in due course of law expenses, charges of medicaments and other appliances, and any fees which he may be entitled. And this is an act of Parliament. However, the criminal law amendments have specified certain special sections wherein treatment has to be done free, and then Penal Code further says that anybody in charge of hospital, public or private, whether run by central government, state government, local bodies or any other, when contravenes the provisions of this criminal procedure code, be punished with imprisonment up to 1 year or fine or both. So the conflict starts right from there. And then Supreme Court here tells all the states first to compensate the victim of acid attack. It tells various states to put in a mechanism to compensate, and therefore they issue a direction that state governments discuss and take up this matter with all private hospitals. Now, if I go through all these words in this sentence, I am surprised when I receive various informations from various activists of the Indian Medical Association that no such dialogue has ever taken place between any private hospital owners and the State Health Ministry. The further direction from Supreme Court in Lakshmi versus Union of India is that hospitals where the victim of acid attack is treated should give a certificate. That's all right. But this tells that Supreme Court knows that all acid attack victims will not be treated for entire of their treatment requirement in a particular hospital, because all hospitals are not equipped to do so. So there is definitely a first hospital and subsequent hospitals. But then it says that certificate is utilized for victim for treatment and reconstructive surgeries within various schemes. So my dissatisfaction here as one of the treating member is when all hospitals are not equipped to treat acid victims, when there is no dialogue between any private hospital and any state health machinery, when there are various avenues in which the victim gets compensation through CRPC, IPC, through state mechanisms, etc. Why is it that a hospital has to treat the victim free? Not only treat free, but provide food, medicament and bedding. These are the wordings in Lakshmi versus Union of India. So I would urge both the Indian Medical Association and the Medical Council of India to really look through this, so that further clarification has to come either from Supreme Court or from Parliament. Thank you very much.
Two dignitaries, both former Secretary General of Indian Medical Associations, and can I invite both of them to please come and occupy the chairs here? Dr. D.R. Rai and Dr. Narendra Saini. We are privileged to have them here. And mind you, don't go by their age difference. Both of them are very vociferous in putting their points across.
Who is younger? Please tell. Or rather, who is older?
I am inviting Dr. R.K. Mani, an intensivist of repute, and he is going to speak on an issue which is very contentious. It borders between ethics, morality and law. Dr. Mani.
Thank you very much. This is a this is a forum and coming together of different professions with the common intention of actually a social cause, improving our social condition, which inevitably impacts on the how we die. It is an end of life issue. Now, end of life issue, we all know that it is not confined to a medical issue purely, but at the same time, it has a deep roots in the medical ethics, right? And then it overflows into the what we think about ethics and morality, and then of course law. So ethics is of course a big universe, and law is a small circle within the universe. So we cannot over legalize this issue, because the primary issue is that there is somebody dying, somebody suffering, and that will come to us all, come to us or somebody close to us. It is going to be an experience, a dying process. It will be an experience which we will have to face, and all the complexity of the dying process becomes something of great importance. What has happened is, in over legalizing this issue, we have just concentrated on one word, that is euthanasia, not understanding the full import of the word euthanasia. Euthanasia is really not about dying people. They're about people who are living and people who are not likely to die in the near future. And that's where it is applicable. So you want to actively kill as an act of mercy. But what we are talking about is not this issue. Where dying process already started, people are dying, and dying is a painful process, not only to the person but also to the family and all around. It is a physical, emotional, spiritual suffering that is going on. And if we are not addressing this process, how we die and the dying process, then we make it a big tragedy, an avoidable tragedy. What has happened is modern medicine, for all its goodness, all its good intentions, has come up with a strange problem of its own making, which is a complicated death. Okay? Atul Gawande said, for all the 2 decades of evolution of medicine, now we don't know how to die. This is a problem, because there is interposition of all the medical interventions, which may save many lives, but for many, it's a tragedy. It's a prolongation of the dying process, and with it comes even greater tragedy. You see, there's one arrow hitting you, which is death, but there is a double arrow. In the same spot, there is another arrow of prolongation, of pain, suffering to the people, kith and kin, and economic destruction. There have been people who have been pushed to below the poverty line after an episode in the ICU, right? And this is generally futile. It's the futile care that leads to maximum expense and maximum suffering. And unfortunately, there are many barriers to improving the end-of-life care in this country. End-of-life care is primarily focused on the pain and suffering of the patient, to mitigate that suffering, and secondly, to avoid unnecessary prolongation and excessive expense and burdens to not only the patient but also to the family and to the healthcare system of our country. So it's got huge ramifications which we have not even touched. It is not that this issue is new. This issue is 40 years old. Ever since intensive care, modern developments, interventional medicine has come into force, come into common use, it is as old as that. So every intervention that we have has an ethical side to it, ethical aspect, dimension, which if we don't fix, it's going to be a runaway, uncontrolled, unregulated exercise, which is what has happened. It can be an unregulated exercise to put a patient on a ventilator, unregulated exercise to do a CPR on him, unregulated exercise to give a lot of antibiotics, and that has already led us to the brink of disaster, right? Antibiotic unregulated use. So everything, every good thing has to be regulated, has to have boundaries. End-of-life care sets those boundaries. What happens is, in every phase of illness, you can't do exactly the same thing. It's not possible. For every phase of life, you can't be doing the same thing. Somebody is facing death, you do the same thing as somebody who is young and has a reversible illness. That is not good medicine. The legal interface of all these issues is, what are the rights of the patient? We have only looked at one right, the right to live. Nobody, no doctor, no medical professional in the world is contending the right to live of the patient. That is why we are here. We want to save lives. But it doesn't imply that there is no right to dying a dignified way. It doesn't imply that technological intervention is an imperative under all circumstances. This is ridiculous. That nobody has said. It is not implied. But we have over-interpreted or perhaps under-interpreted the Article 21, saying that there is no right to die, which has come out of Gyankor case, which is not a terminal illness issue at all. So if we take the context out, we will get a very strange conclusion that there is no right to die. I can't put up a banner in the ICU saying that there is no right to die, okay, and tell the patient, sorry, I have to put you on a ventilator because Article 21 says so. That is not the implication. There is a privacy issue and right to die in dignity, which is hidden in that Article 21, which we have to explore and open up and actually nail it, okay. Otherwise, we are going to have these strange interpretations. And there are other rights which have not actually been spelt out. The right to be free from pain. Okay, we cannot live forever. Okay, we cannot prolong life forever. But yes, we can mitigate pain. We can mitigate physical, emotional, and spiritual pain to the extent possible. This is why I trained as a doctor. Okay, I can't save everybody. But my primary professional instinct is to mitigate pain. And if I can't do that, if our laws don't allow it, how can I respect myself as a professional? So right to palliative care, refuse unnecessary treatment, this right is inherent in our consent, common law consent. You are offered a treatment, you got every right to refuse that treatment. It cannot be interpreted as suicide or attempt to suicide or euthanasia. Nowhere in the world it's interpreted like this. I do not know where we have got this idea. I don't know where we have got it. It's not there anywhere else in the world. You have a right to refuse. That's why the consent is there. Even if it is perpetrates to save your life, you have a right to refuse. I cannot operate on a patient without him signing. Therefore, I cannot put a patient on a ventilator without him signing. And mind you, this right as a citizen is fundamental. It's there in our constitution. It's there as a right to liberty in our preamble. So that cannot be trumped by anything else that comes later on. That's one aspect. Second aspect is that the right to refuse or consent exists even if you lose capacity. You can't say, if it's a conscious patient, I'll take consent, but if he's unconscious, I don't have to do anything, I can just, through best interest argument, I can jump on him. It's not possible. That right has to be expressed and represented through mechanisms, through tools, through instruments. But unfortunately, we do not want to use those instruments. The surrogate rights do not exist spelt out. Okay. To give your organ for transplantation, your spouse has to give consent, is it not? Similarly, to be able to do anything to a patient who has lost capacity, your nearest kin, whatever be the hierarchy of surrogacy, has to be defined and be in place. What has happened is, the legal issues are not addressing the right thing. You're always discussing only euthanasia, right to live. But world has moved on. End of life care has become a very important issue in every developed world, so that there are laws now, well developed laws in most of the countries, and there are also legislation in at least half of them. And we haven't got started. The MCI code has to come up to what is the requirement of the times. If it is 20 years old, then our concepts are going to be 20 years old. You see, we have only got one section for euthanasia and MCI. It says only something about brain death. That brain death, there has to be concurrence of 3 people. But it has to have to come up to scratch. It has to be expanded to talk about all other issues concerning end-of-life care, not just euthanasia. DNR has been confused with euthanasia. DNR has got nothing to do with euthanasia. In fact, it's the other end of the spectrum of treatment limitation decisions. Completely other end of this, opposite end of the spectrum to euthanasia, and we have disallowed DNR, I don't know for what reason. We think we are disallowed. There is no law really actually spelling out disallowed. The main thing is, we have got 2 draft bills of the Law Commission, the 196th, it's not 176, 196th, and the 241st report. It is languishing. Our lawmakers are not finding time to read it, and because it's so important. 2006, 2011 is still languishing. It's clearly stated euthanasia is distinct from the end-of-life issues, withdrawal with the withholding issues in the clear circumstances, and there is refusal to accept medical treatment. Treatment does not amount to suicide, and so forth. The problem with these reports, and also as with Aruna Schonbock case, is that they accept these principles, but they have not clearly spelt out how to implement these principles in the patient who has lost capacity. Our law says that don't believe in relatives. They could do that patient in. Don't believe in the doctor. He could have other consideration. Only believe in the law courts. This is not possible to implement, because when a patient is dying, there are 3 stakeholders, only 3 people around him, his family, his doctor, right? Only 3 people are involved in this. It's a very serious matter. When we walk into ICU every day, you are seeing dying patients and you are having to support them, you are having to do your best for them. And if you have to go to the law court to do that, it is not possible. It is not implementable. This is not the way it is done anywhere else in the world. Only thing is, yes, court declarations are possible in case of dispute. In case of real impasse, in a futility case, you can go to court. But it cannot become a daily affair, then we cannot move. Even in a more ethically challenging condition like a transplant situation, you only sit a local ethics committee which deals with it. And therefore we have to revisit these things, and there is no way no way for an advance will or a durable power of attorney as an instrument in this country, which is also a huge gap. It is disallowing our liberties. It is actually scuttling the civil liberties, actually going against the grain of the preamble of the Constitution, because we have a right to express our wishes the way in which we are going to die, as per guaranteed by our Constitution. There is no way that a paper, a draft bill can say it should be disallowed because there is potential for misuse. That is not possible. All of our liberties has potential for misuse. It's not that we can't have them. So with that I'll stop because our time has run out, and this is an extremely important matter, ladies and gentlemen. It's to deal with our civil liberties, it's to deal with the way we die, it's to do with the way we practice medicine and how doctors are allowed to practice medicine. It's the way how we can conserve our resources. It's the way how we can reduce the antibiotic burdens and all the over treatment, disproportionate treatment burdens that we are unnecessarily carrying on our shoulders. Thank you very much.
Thank you, Dr. Mani. In fact, there are many speakers, but keeping in view that our honorable chief guest has to leave early, we'll modify the program a little bit. First of all, I'll call Dr. Geetika to read the message that has been conveyed by the Honorable Minister of Health, Dr. Nadda.
Ladies and gentlemen, on behalf of Mr. Jagat Prakash Nadda, I would read out this message to all of you. At the outset, my heartiest congratulations to the Institute of Medicine and Law for successfully organizing the first National Convention on Medicine and Law 2015. I also congratulate the medical associations, doctors, lawyers, editors of medical journals, academicians, and also the representatives of the Ministry of Health and Family Welfare, Medical Council of India, and National Accreditation Board of Hospitals and Healthcare Providers, who were a part of the deliberations. In a functional democracy, all the stakeholders must be involved in the process of decision making, directly or indirectly. But in a country like India, and on a subject like healthcare, this involvement is an issue. Therefore, initiatives like this convention are the need of the hour. This convention was unique in two ways. Firstly, various stakeholders came on a common platform and discussed legal issues of concern in the presence of the representatives of the government and regulatory bodies. Secondly, the government also tried to explain its stand on various issues. The recommendation of this convention will certainly provide us the requisite inputs in dealing with legal issues relating to the healthcare segment. I would strongly suggest that the convention should be round-the-year exercise rather than being a one-day event. Congratulations again for this year's success, and my best wishes to all of you.
For Institute of Medicine and Law, I have to say a few sorries and a few thank you, a few clarifications. Two clarifications that I gave even at the Mumbai event. The first one was that we were criticized that, hey, around 3,000 doctors and lawyers registered on your website, and you called a handful of them, only 150. The answer was, and the answer is, that in a crowd of 1,000, such serious issues can't be debated and deliberated. We called consciously only the office bearers of medical associations, thought leaders amongst doctors, and doctors who have done law or are practicing as medico-legal experts. We definitely did not call the others. The second criticism was that, look, you have called only the doctors, patients and hospitals, but the patients are also an equally important part of this healthcare sector. Yes, this is our first experiment. We did not call them. Next year we will certainly call them. Third shortcoming on our part was we were not able to communicate ourselves properly, especially with the doctor fraternity. I see Dr. Paintse here. Fortis Hospital has taken this initiative on a very corporate level thanks to Dr. Paintse and his team. And when I spoke with the local connect there, Dr. Leena, a day before the convention, in fact, she was trying to get in touch with me. She said, oh no, doctors are very much afraid. There will be lawyers, judges. We don't want to get into that pachada. So somewhere there was miscommunication on our part. We were not able to communicate properly. Our apologies. 3 persons need to be thanked very specifically. One of them is Dr. Rajesh Narwal, who is sitting up there. He represents WHO, World Health Organization. Officially, World Health Organization is not part of this convention, but many leads, including Dr. Ved Prakash Mishra, Dr. Kantikar, were passed on to us by the World Health Organization. And in fact, we should have a session on Clinical Establishment Act, was their suggestion, a very fruitful suggestion. Thanks on behalf of the convention, on behalf of Institute of Medicine and Law. 2 corporate hospitals helped us a lot. Apollo and Fortis. In fact, today happens to be the founding day of Apollo Hospital, yet Ma'am Sangeeta Reddy has been very kind enough to ask Dr. Trivedi to specifically remain present here. Dr. Paintse is here. Thanks to both of them. Association of Hospital Providers of India, AHPI, was there with us. Dr. Alex Thomas did very clearly raise the issue of capping compensation. We would certainly like to thank them. One sorry to Dr. Barun Naik. Dr. Barun Naik, sorry. And that sorry is, he had raised a very important question, a very important issue, a very constructive issue. Law can be used constructively. And the issue in hand was that if certain equipments could be reused legally, the cost of healthcare could be brought down. The entire organizing committee thought it fit that this is one issue which is something different. Let us keep it at end. And then at the end, Dr. Naik was given a very short time. And on the video, I did see him complaining that, Are, you have given us only 25 minutes. Our apologies. Friends, we are also thankful to 4 corporates who have helped us in identifying and bringing doctors. Wokhard Pharma, Cipla and MCure. And obviously our partners, our publishers, Medna, Wolters Kluwer also need to be thanked. I will, my duty as the honorary director are over. I'll now ask, and USV also needs to be thanked. I'll request Advocate Balaji, who was heading the academic part of this convention, to just share a few words.
Excuse me, can I just say a few words?
I'm sorry, I just tried to rush in. I'll request the Honorable Chief Guest, Dr. Jagdish Prasad, to share a few words with us.
Actually, guest on the dais, ladies and gentlemen. If you ask me very frankly, when this lady came, I say, what I have to say? I don't know about what is the medicine and law, because throughout I have worked in the government setup, and if whatever the doctors do in their own sense cannot be said wrong if his intention is good. So I never thought of law actually, if you ask me very frankly, because when we take some decision about any things, we take the decision in favor of the patients. Our intention is never to harm the patients. So this is the question which has come up now, and there are lots of things to be talked. Since I have less time, only few things just I want to say. I was just going through the white paper. I think definitely I will look in the Clinical Experimentation Act, what has been pointed out in the white paper, and I told Dr. Ray today that we will discuss. That is just we are not saying that medical profession is unregulated. We are telling that system is unregulated. So white paper has written the medical profession. Nobody has said the medical profession is unregulated. Doctor is always regulated. If doctors working in the corporate hospital and doing some investigation which is not required, because they are forced to do by the corporate peoples. This is unfortunate. This is an open secret. Everybody knows it. So that to stop that corporate, the regulation has been put up. And we have put up the standard treatment guideline. Not that you must follow that, but this has been made by so many people. So little divergence should be there. Because I just give one example, because I come across many such problem of unregulated system, many days. Patient has been operated for mild hernia. We are paying the bill of 4 lakh rupees to the corporate hospitals. We are operating pyrexia of unknown origin. We are paying about 6. I think what I understand, this convention, if you are putting the doctors and law, I think itself is a wrong way to say. Only thing now it has come, because doctor always treat the patient in very good sense. He never, suppose you are doing some test in the eye or putting some drops or some surgery and the patient moves the head and sometimes gets injured. It is not your fault, even you are telling the patients. So to blame the doctors is I think is the last thing should be done. But doctor has to be cautious of themselves. If you are, the most important among the doctors is they should do the ethical practice. They should be true to themselves. If you are a surgeon, if you know the surgery, that part of surgery, then you do it. If you have no expertise, please don't try to do that. If you are doing even laparoscopy in any place, just I was telling, and you think that laparoscopy is a small surgery and you don't have a ventilator in your nursing home, you have no business to do the laparoscopy. Because even a small laparoscopy also can be misshapen and may require the ventilatory supports. So these some things, you have, as a doctor, even you are giving the normal saline, which may have some fungal infections or something, can put the drug reaction type of things. So you have to be also very cautious of that. So you should be ready for any emergency which can occur when putting the IV drips that can put you in the law. So even you are giving the blood transfusions, even you are matching the group very nicely. Even you know the HIV, every test has been done. Still there is some antigen which is not tested in the blood, can cause the blood reactions. So these are the so many things, but why the law has come up? Because we have to be, first of all, we have to be true to ourselves. We have to do the ethical practice. We should do the practice as per our knowledge. We should be clear to the patients. there should be transparency with the patient itself. We should not put the patient on unnecessary medications. We should have an open discussion with the patients. I can tell you, I am a cardiac surgeon and sometimes patient die. And still patient relative touches the feet. Because we were our best things, we have explained this patient is class 4, this is the consent has been taken properly, patient has been explained nicely, post-operative patient has been taken care of as much as we can do. Time to time patient relative has been made to understand. Come and talk, patient has been operated conscious, please come and meet and talk to the patient. After that something happens, it can happen anytime till the patient goes home. So what I want to convey to all the doctor community, that first of all we have to be correct ourselves. We have to practice according to our knowledge. If we have a doubt, you must consult other persons. If you feel that it is not up to your level of knowledge, you immediately refer to the senior people. You should not hesitate in doing that. If few things are followed, I don't think that law should come in our way and we should read the law. Because doctor community, I think, is the most educated society people, most educated people, because we have a feeling which nobody has a feeling. The doctor is the only community which has a human feeling. Even whatever we are busy, if somebody asks, Doctor Sahab, हमको बुखार एक दवा लिख दीजिए, we will stop and write some drugs immediately. Because the sensitivity which the medical profession has got, as nobody has got it. And I want that if anybody consumer members are here, analyze properly. There may be mistake somewhere can occur. There may be some negligence, but not intentionally. Nobody does intentionally harm to the patient. But for the doctor community, I want to say that please don't do such practice which you don't know. You display your qualification. You tell about yourself, true to the patients. If you are true to the patient, even patient will not harm you. Patient will never harm you. But that is my experience of last, I think, practicing last 40 years, nearly 39 years of medical profession, I can tell you. I post-graduated in 1976, and I tell you that I have never faced any problem, anything in my life. So when the Gitika came to me that there is a convention, मैंने कहा मैं क्या बोलूँगा, मुझे तो मालूम नहीं कि मेडिसिन और लॉ भी कुछ होता है. And there was a case, definitely, there is one case from the Polo, the judge given the, see, that is not correct. That we don't like to be given the such type of judgment. Cerebral palsy can occur to anybody. Even suppose children hasn't cried and cerebral palsy, you don't know until the postmortem has been done. Whether the cerebral palsy just occurred because of hypoxia, or even sometimes you have aspirated in the, you can't prevent when you are making delivery, the aspirations of the child. And that make it take some time. And the patient can have a asphyxia and can have a cerebral palsy. I think the judges also has to be a doctor. They should understand. Judges cannot be non-doctors.
We have one doctor there.
No, they have to be knowledgeable doctors. I'm not, there is nothing to laugh. Medical profession has gone down today. With all the respect to my profession, the way the medical college is coming in the country, the way the education is given in our country, is not perfect. Not perfect, I'm just telling you. It requires much more. I was talking to Devi Sethi. He was trying to say me 2 days back that, Dr. Prasad, we want to start clinical cardiology. So I said that, why you are putting 2 years? Why don't 1 year? 1 year is enough. No, Dr. Prasad, you don't know. Today the medical profession, they are MBBS doctor को एक IV drip लगाने नहीं आता. So that is the painful. That is the painful parts on our profession. That should not be there. So I am just telling that judges and the other people and doctors community, I want to say only one thing. please be very clear cut to the patients, open to the patient, because child never complain about their parents, because child knows that parents will always do good for them. Doctors also see the patient in that way. I'm just telling you very frankly. But I don't know about others. And even I have two daughters and both are doctors. And they are very devoted as I am. And I don't understand, but they also don't want to neglect the patients. If patient is having some problem, you must look in that. If you don't understand, ask your seniors. And the hospital, there definitely is some problem in the hospital. So for my message to the corporate hospital and other hospital is that you must display the always corporate has a well qualified doctors, well experienced people. There is no doubt. There is no doubt about that. And I think today the 70% of patients are going to the private sectors, and that is why the only thing the private sector has to be a little bit aware of the things, that they should be very open, very transparent to the patients. Then they don't have to see the legal things in their lifetime. That's my only advice to all the corporate. Be open, be very, as you are seeing the patient, tell the patient, now see, your patient has expired or not expired. If the brain death has occurred, please declare the brain death. If you want to keep, if you have something in your mind, you keep it. We should not keep unnecessarily on ventilators. We should not also off the ventilator if you think that there is still something in the brain is surviving. There's lots of law question comes. And definitely I will convey to all my doctor community that consent, written or unwritten, is maybe important as per the law is requirement, but my consent is that if you can take full confidence of the patient and relative in yourself, that relative should understand that you are treating like a parent. I don't think their law will come in our way. That are my only things to all of you. Thank you very much.
To my lawyer friends, Dr. Jagdish Prasad, though he heads the central government, he is in an administrative capacity, but he remains a doctor. So though he was trying to speak to the doctors' fraternity, he also was trying to express his pain that how come law interferes with medicine. Sir, thank you for being here. I request Advocate Balaji to please share his thoughts.
Good evening, honorable judges, distinguished guests and friends. I'll be very brief. Wise men have spoken before me and they'll speak after me. We have two inspiring people with us, Dr. Kantikar and Dr. Gupta. Sir, your presence really encourages us and inspires us. IML has made a very humble beginning. It has given a platform to people, for thought leaders who, after thorough, lively debate, intense debate, active discussion, have spoken in one voice. The voice being, the doctors want to operate in a safe and a secure ecosystem. That is the one voice they've spoken on. The white paper is a convergence of many viewpoints, thoughts, approaches, and it is only a beginning. I would end by saying, Spinoza in his work, famous work Ethics, said as follows: everything excellent is as difficult to realize as it is rare to find. Therefore, let us not worry about where the excellence comes from. Let us make our actions count. And with that, I end my speech. Thank you very much.
Advocate Balaji has set the stage for the legal fraternity to take So before we move further, I will request Dr. S.M. Kantikar. He is honorable member of the National Consumer Commission and actually a bridge between doctors and medicine, because he is also a MBBS MD. I'll request Dr. Kantikar to please share his views with us.
Good evening, everybody. Dignitaries on the dais, of the dais, my professional colleague, medical professionals and legal professionals, both are my colleagues and my friends. Really, this is very nice exercise which Advocate Bajpayee and his team, which took this momentum to arrange this National Convention on Law and Medicine. I have joined the commission 2 years back, and I will share my experience or my views where the doctor fails and why there are more litigations on the doctors. Time hai na mujhe? So at the beginning, Bajpayee ji, he told there are two members who are on the chair and from National Commission who decide 99% cases against doctors. I was afraid.
Of medical negligence. Sir,
Of-
civil cases and criminal. I'm sorry.
Yes.
I'm sorry.
So I am worried there should not be any fear for the doctors that they will be victimized unnecessarily for the negligence, either National Commission or District Forum or Honorable Supreme Court also. So first, take out that apprehension that we are entangled, because doctors are entangled with many laws, from our common laws plus special laws like clinical establishment, then environment protection, biomedical waste, so and registration, Drug and Cosmetic Act, everything. In addition, now from the VP Shanta's case brought all the professionals as a service provider, so we are liable, the doctors. So there is a threat of the lawsuit which caused increased medical cost now. I will not discuss the past and other, but the scenario today, in every conference where I attend throughout India and everywhere, most of the doctors, they ask me the question, they are worried. And why there is worry? They are first ignorant of law. That is main thing, because every person has a right, or I think he should learn the law. If doctor is served one notice, just simple notice of the court, he will be worried what happened and what he will not recollect. Yes, what happened to me and why this patient has served the notice. So the question comes, how the case evolves. One is doctor-patient relationship. Just Speaker Dr. Prasad, he told most of the problems will be solved at the initial stage only. If you have good doctor-patient relationship, I won't think there will be any chance of litigation. Most of the doctors, it is the common perception of the society that doctor never speak with the patient. Yes, he will write the prescription, okay, go to this lab, investigate, bring the report. If he bring the report, they won't see the report. Yes, okay, take this tablet, come after 8 days. He is paying. You are giving the service, you are taking the consideration. And just if he is paying thousands of rupees to speak for only 1 or 2 minutes, then the doubt comes in the patient's mind, and that will be the trigger point. If something goes wrong, then the first instance he will tell, yes, he has charged me more, he has not guided me properly. So there should be healthy doctor-patient relationship. Then second is very important, the consent. Dr. Prasad covered everything. The consent is very debatable issue, and the Samira Kohli's case discussed various issues, and Honorable Supreme Court laid down very much principles. And then we discussed many cases, Bolams and Bolithio. Then now new concept of brave Bolam, it is coming. Dr. Gupta will discuss that and how to regarding compensation also. So this is the one part, consent, where the doctors fail to take the consent. The courts believe the doctor, but courts believe more in the records. It is very important. The documents speak in the court of law. Your version will not be, because patient will tell, 100% patient will tell, cardiac surgery he has not taken consent. It is unbelievable when you are subjected for cardiac surgery. The patient, there should be complete discussion, counseling with the family members, the doctor or some resident doctor will do in the hospital, and finally he will be operated. But courts are handicapped because the documents are devoid, of proper informed consent. Now the concept of informed consent is very important, and I think in your deliberation you have covered in Bombay, and regularly it is coming up. Then the standard of practice is also, I will say, instead of standard of practice, every doctor will try his level best to treat the patient. But standard of practice, I will give more weightage to ethical practice. What are the ethics? Unnecessary investigations, corporatizations. So whether it is correct, because as much as you as a doctors, they burden the patient, you certainly think he will be the potential litigant at one point. If you do ethical practice, the doctors do ethical practice, most of the problems resolve at that point only. I think the deliberation in Bombay, which I certainly missed, I got some the summary proceedings from Advocate Vajpayee, and I have gone through. You have discussed the compensation also. Regarding compensation, yes, there are many questions in the conference which I faced. The commission is awarding very high compensation. This Honorable Supreme Court awarded 11 crores compensation. One doctor asked me, I am practicing at district level, and if any court fines me 1 crore, then I have to close everything, and it is totally smashed. So certainly, why the compensations are awarded at that higher stake? We should think, because the rampant corruption in our practice, rampant ethical practices, because to set right this thing, some deterrence is necessary, which I feel, but still, if the doctor has practiced with his reasonable practice and with the reasonable care, what they say, as per Bolam's test, most of the courts will not punish any doctor. Punishing the doctors, we also know, the courts also know, it will lead to disservice to the society. Certainly, patients will be at the loser side. Then for the compensation, what you should do? Whether there is any need of any alternative dispute resolution. Yes, I feel after sitting in the commission, what I felt,
ADR system will certainly helpful, and most of the cases, apart from our medical also, most of the other cases will be solved by alternate dispute resolution. My brother, he will talk on alternate resolution also. So what are the goals of litigation system? Why this medical negligence brought in the, what is the goal? First goal is compensate the plaintiffs for the negligence, then discourage the practice of negligence, and third is there is need of exact corrective justice. We need this thing to be addressed properly, then only regarding medical records, I think this deliberation should suggest the government or the authorities how to keep the medical record. Most of the doctors, they don't know what to do. In every time I suggest the doctors, your practice is rampant, you are earning more, everything, whatever it is, and I wish them they should flourish. But at least give half an hour for yourself, sit in the chamber and today what I did, whether there was any wrong from me, shall I call the patient, shall I apologize? So acceptability, and where the doctors fail, I have not gone wrong, but if you have gone wrong, accept and correct it at the point. What happens, patient, when you discharge the patient, the limitation is around 2 years, or in some cases it will be continuous. If diagnosing malignant tumor as a benign and the biopsy and other thing, it will be after 10 years patient may come and you can't defend the bills, which will not help in the court of law. And many hospitals, despite the medical council regulation, they won't issue the medical records to the patient at the time of discharge or after the application. The regulation 1.3, it categorically says if anybody, the close relative or the patient himself applies, the hospital should issue the records within 72 hours, which they won't issue. When the case is filed, they will tell we have destroyed the records, but the Act says medical council 3 years. DGHS says if they are hospital records, yes, for 10 years. So where is the basis? Some concrete basis should be there, and that is the need of hour. Then I think regarding the compensation and the fear, I have read some articles and some international journals and other. There's in 6 countries there is a no fault compensation system is there. Whether we can adopt that no fault compensation, because recently you might be knowing our honorable PM, Prime Minister Narendra Modi, I heard in Mann Ki Baat and newspaper also, he has announced regarding the rampant road accidents, he announced there should be cashless insurance facility for first 50 hours. So why not we propose there should be cashless facility to the every patient who comes to the hospital, because then it will reduce the corporatization and the chances of negligence also. Because many times if the accident victim comes, the recent episode of dengue, the patient has to run from pillar to post. When he is serious, the patient, what is our duty as a medical professional? At least see him, don't toss him. So if we adopt no fault compensation also, it will certainly help, and it will compensate quickly, very quickly, but there are chances the compensation may be less or so. So with this word, I think this is very wonderful gathering, and more than that, I have learnt more from the learned doctors, the advocates, the speakers, and I think the regulatory bodies like MCI and any other bodies, they must lay down the rules with the health department, health ministry, to monitor the working of the hospitals and to avoid the medical litigations, because many times the National Commission judgments we refer to Medical Council of India, but we never get any feedback what action or what they have modified or what they have initiated any action or formulated any rules. So I feel it should be collective work. We all should take the collective work. We should not blame anybody, either judiciary or legal or lawyers. So with this, thank you very much for calling me. Thank you. Thank you.
Mention. Dr. Mishra said that 4 intelligent men will never work in one direction. Sir, there were 10 intelligent men working on the white paper which is there before you, and for the last 5 days we have all hardly slept, and that is one reason, including myself, and that is one reason I said 99% of the cases, my apologies, doctors are head negligent. We have another learned member of the National Consumer Commission, Dr. B.C. Gupta. Dr. Gupta was instrumental in bringing out the first act in Punjab against violence against doctors. So in that way, he is an activist also, and today he is obviously a honorable judge of the National Consumer Commission, Dr. Gupta.
Honorable dignitaries present on the dais, I am grateful to the organizers having given me this chance to say something. Although it is concluding session, so I was just thinking whether it is a starting session now or a concluding session, which I will say later. So I must utilize this opportunity to share some of the experiences, the situations that we encounter every day. Few of my colleagues from the bar are also sitting here. They are very active participants in the whole process. I must comment that this is a very unique initiative. Rather, I was looking for it. There has to be some organization to fill up the gaps, to bridge the communication gaps. So this is Institute of Medicine and Law. So I'm very happy they have come in a very big way. Mr. Bajpayee, Mr. Balaji, they handed over a booklet, rather handbook, 2014. I have gone through some pages of it. A very, very relevant book for all practitioners in the whole affair, whether you are a doctor, whether you are an advocate, whether you are a judge, or you are a patient. So it is relevant for everybody. But I am just throwing a proposition here. You come to my commission, or you may not come, everything is on the website. On the subject in the category of medical negligence, you pick up any 10 files, old files and new files, any subject, whether it relates to cardiology or it relates to ophthalmology or it relates to gynecology, and anything you pick up. There are so many issues there are so many gray areas where people like us, people living, sitting in this room, whether the number is 10 or 100 or 1000, we are required to deliberate, to arrive at some kind of tangible solution. As Dr. Kantikar says, no use of blaming anybody. But there are so many gray areas. I will just give you only 3 or 4 examples in the limited time at my disposal. First point I want to mention, it is not mentioned even in your handbook. I am there for the last 2 years, having spent about 40 years in the civil service. So there is something Ayurveda, allopathy, homeopathy. So one Ayurveda doctor, so he is in the dock for medical negligence. So he is posted in a village dispensary, very remote dispensary. So one patient comes to him, one lady with delivery, and he performs cesarean operation. And then there is complication, and then there is negligence, and whatever it is. Now the point is, we just asked him. I said, have you done it? He said, yes, I have done it. I said, why? Are you authorized? He said, yes, I am BAMS. So I said that, is there some line, is there some defining line? He says, I don't know. But I was the only doctor in that 20 kilometers of radius. So had I not treated the patient, even then you would have caught me. That why have you not attended to him? So ladies and gentlemen, till today, I have not got any conclusive answer to what extent those people can go. I spoke to my counterpart, some secretary of some Ayurveda department. I spoke to IMA. There are many friends, I belong to Punjab. So many of them are there. So I am always in touch with them. So I talk to many of them. So far, no answer is coming. Many other areas. So there is a situation. Insurance company doctor says something else. Treating doctor says something else. So it was a young girl, lipomyelomyelangosine. So the issue is whether it is external or internal. So one doctor says external, another says internal. Now what do we do? Now some of my colleagues, they do have, I must confess, they do have this notion that there is a paper book, there are pleadings, so arguments by the lawyers, so we confine ourselves only to that and we don't go beyond that. I think we will be failing in our duty. So I talked to Dr. Kantikar. He spoke to head of the anatomy department in one of the hospitals in Delhi. So they sent us a 4-page research paper written by 4 Chinese scientists, and that provided me the solution. So that is the point. I mean, so many areas are there. Whether you have to get educated, only then you arrive at a correct solution. Then ethics, they say medical ethics and all that. I give you one more example. A case of orthopedics, femur head fracture, something called SP nailing technique, Smith-Patterson nailing technique. And the doctor, 73, postgraduate, Bombay, practicing very well. He came to us. He says, I have done this. So where I have done anything wrong? So from the other side, so they said this is an outdated technique. He should not have done it. He did it once, failed. He did it second time again, failed. Then third time, I went to a different doctor. So what should be done? So I didn't know what to do. So what I did, that I want to share with you. PGI Chandigarh. People know us very. I spoke to 3 prominent doctors. One of them is present head of the department. One of them is a vice chancellor of a university. And the third one has been the head of the department. In all 3 cases, ladies and gentlemen, the answer was, he should not have done this. But when I asked them, has he done legally anything wrong? So they thought for a while and said no. But this has not been declared outdated by any medical fraternity. So we discharged him. So my point is, lot of discussion, lot of debate, lot of things are there. I can give you hundreds of examples. So where these kind of things are required. And Dr. Kantikar instructed me on this bolum, I must say 1 minute only. That is something standard of care, that is reasonable care. And body of medical professionals, if they say, whether they may be 10% or 90%, nobody knows. So then the doctor is supposed to be having no negligence and all that. But now it is changing, you know. I'm saying that despite hundreds of landmark judgments, this jurisprudence, the consumer law, it is developing, and to my mind, it is still at a, Mr. Bajpayee, at a nascent stage. And people like you can play a very meaningful role, very positive role in building up this jurisprudence that will be in the interest of all the stakeholders, whether they are patients, whether they are corporates. You can't blame the corporates also, whether they are doctors, so whether they are anybody, they may be judges. So this is the need of the hour. And then on ADR also, we have many examples, you know, it is there in the white paper also. The point is, at the initial stage itself, we have tried this, that when you tell the person that, okay, hold a dialogue, and whatever you want to do, have something ex gratia, and then withdraw your charges against the doctor. So there is success in many of the cases. So that is ADR, that is introduced in 2002 in the CPC, section 89 of the Civil Procedure Code. So it is a huge success, it must be tried. So having said all this, I won't take more of your time. My only request is that this institute, we are at your disposal, anytime, anywhere. Honorable Minister also said that this process should go on around the year, not on one day or the other. So this kind of dialogue, this kind of process, it should go on. I wish you all the best, and again saying that this will be very, very useful, very, very helpful to all the stakeholders. Thank you very much.
Now I am in a dilemma. I have three speakers, Dr. Barun Naik, Dr. Imran and Dr. Suganti to speak. And I have two trade unionist doctors, Dr. Saini and Dr. D.R. Rai to speak. And the time and hand is far too less. And obviously I would want the keynote speaker to speak at least for 15 minutes. When for the first time, in fact, Dr. Narwal's colleague introduced us to Dr. Ved Prakash Mishra, Dr. Buddha. And after listening to him for the first time, today I met him for the second time, and I have taken only one concession from him, that sir, whenever you meet me, I will touch your feet. It's Saraswati which really comes out of his Shri Mukh whenever he speaks. And you all will agree with me, maybe a few minutes later. So sir, may I ask the keynote speaker, if 10 minutes we can, no sir, no, not for you, for others, if I can ask them 2 minutes. No sir, I'll request Dr. Suganti to come and just speak for a few minutes. I want to listen to him. I'll ask Dr. Suganti. 10 minutes we'll finish off and then we'll.
That the session of hospital administrators that was convened on 6th September. The session on hospital administrators had a few points to make. I would just voice out the relevant, important ones because of shortage of time. The first thing they wanted is a guidelines for the hospital with respect to manpower, doctors, nurses, technicians, etc. What would be the ideal manpower strength, the ratio vis-a-vis the patients? This is not there anywhere in India, and important guidelines is very important. Apart from this, for important departments, specifically to mention was the operation theatre. To get really good qualified registered nurses to work in the operation theatre, the way our healthcare system is, we face shortage, not only in major hospitals, but definitely also in smaller nursing homes. Whether we can have technicians qualified, if so, what would be the qualifications? Because one has to meet the requirements. Tomorrow we do not want to be slapped with saying that so and so nurse who was assisting was not registered. These are small issues but very important. So staffing pattern, guidelines for theatre personnel and other important departments was also found wanting, which the hospital administrator desired. The other issue that was raised about is the emergency management that has to be rendered to patients who come in a life-threatening emergency. No doubt, with the Supreme Court judgments Parmanand Katara and Mazdoor Samiti, case Mazdoor Samiti, we have to give the emergency treatment for patients coming with life-threatening emergencies. However, what happens is the revenue. Is there any method of compensation to the hospitals, whether corporate or any other hospital, the amount of money that is spent to stabilize the patient? And once the patient is stabilized, we transfer to another institution. What happens if something happens to the patient on the way? If the patient meets with a casualty, death, then again the original hospital is slapped with negligence, and what is the liability? Did you stabilize to the point where the patient should be stabilized? What is the level of stability, that is required to be established before you transfer out? There are no guidelines on this, So tomorrow the question is, did you transfer them very early? You have to wait for it. And of course, reimbursement money, whether any setup could be made so the hospitals are more comfortable about giving treatment. Apart from these life-threatening emergencies, any other acid attack and other victims where of course again money is a big issue. Drugs which we prescribe, patient has a right to procure it from outside if they want. That is their basic right of the patient. Now, if the patient procures it from some other pharmacy and God forbid they are misbranded, spurious, adulterated, we administer in our hospitals. Liability of the hospital, because the place of administration of the drugs is within the premise of the hospital. Tomorrow the hospital is again blamed. So these are important issues where the hospital administrators feel the heat. Again, Dr. Mani has spent enough time about end of life care. When to pull the plug, should it be just a dama? Today you have to give, legally speaking, only a discharge against medical advice is the way out. There is no other way out. Because even Aruna Shanbag is applicable only in PVS, and that is a very long time, 6 months, 1 year you have to wait. So that's it. And, okay. And the closing statement is about mob fury, vandalism, attack on doctors. And the thing they also feel, the last final closing statement is an act for medical record department. Though they say the medical code of medical ethics says about authorized representative of the patient, the definition is not there. Today the wife probably wants, yes, it should be revealed, the deceased husband's record should be accessible only to her, but the son and daughter also wants it, should be revealed to that. What about the retention? There is no written law. Destruction, scan, digitalized records. So basically the administrators feel, yes, medical records are very important, sir, as you mentioned, but a defined law, something, like a data protection act or something, would be really helpful, because this is the biggest defense in a court of law. Thank you so much for the time.
Dr. Finish off your
Good evening to all the audience. On behalf of the Society for Emergency Medicine India, it's a privilege and honor to address and bring about the concern about emergency medical care, both to the expert audience here as well as the honored dignitaries. It was a very difficult decision because the concerned stakeholders and people who take care of citizens in an emergency include police, ambulance personnel, call centers, the bystanders who are there, the hospitals, the emergency rooms, and both in private and government sector, and the specialty care which continues. So the entire process has to be stable, the chain, to maintain the chain of survival for a patient in an emergency. The development and the emergency medicine specialty is very decentralized. Education is growing at its own pace. The process is also growing at its own pace. People are creating policies in different directions. There is no central regulatory body for this. So we debated in Mumbai a lot with everyone regarding this, and we came about with 6 recommendations which we thought about. The first one is the incorporation of the EMTALA Act. This EMTALA Act is existing in the United States, which guarantees emergency medical care to every single citizen irrespective of any sort of a bias. So we recommended that the EMTALA Act be defined for our standards in in India and to be brought about. The second thing which we required was that there should be a law to prevent violence in the emergency rooms, to protect the doctors and the other staff, not just the doctors. And this law really existed, but the awareness was very, very less. So the recommendation was to increase the awareness of this law so that both the public as well as the healthcare professionals understand this. The third is that in the state of Gujarat, there is a Gujarat Emergency Medical Services Act which was implemented in 2007, which gave something which was similar to EMTALA. And all the other states of India need to adopt this and somebody has to make sure that it is adopted and implemented uniformly across all the states of India. The fourth recommendation was a Good Samaritan law to protect all the citizens who help first aid and give first aid to all the victims who are in an emergency and not to harass them unnecessarily. We also discussed about do not resuscitate orders. That was obviously within the territory of the critical care. So we will take the recommendations from the critical care. The last recommendation which we deliberated was the legal validity for the emergency doctors practicing outside their skill expertise during in an emergency. This includes that the MBBS doctors who are working in remote areas need to be allowed, if they are confident enough, to perform skills and procedures which are beyond their expertise, just to save the life of the patient, and they also must be protected. So these are the recommendations, and I'm very thankful for Honorable Mahinder sir here that we are allowed to speak about emergency care law. No other body has put this issue up so at a national level. So on behalf of Society for Emergency Medicine India, I thank you very much for this.
And Imran, I thank you for being very brief. Now I'll request Dr. Barun Naik to please, sir, no time, sir.
Because no one is sticking to the time. And so one thing I just wanted, because there are many issues which keeps on bothering us, but then one issue which was really very pertinent on that day which we raised was the reuse of single-use item. Because these days, because of obvious commercial reasons, companies are putting more and more items to just because when they put one mark over there on the seal that it's a circle, 2 and cross, then it means you cannot use it second time. The thing is, no one questions the company that why have you put it that no single, it's only single use, why not second use? But everyone is, and say, wherever, suppose I asked Dr. Sugandhi that, okay, can we use this? She said no, because it's written 2. I asked my microbiologist, can I use it? No, because it's written no 2. So in that situation, I think there should be some law to protect. In US, there are law where the same items can be again can be processed and again can be supplied at a much cheaper rate. If my hospital can say one instrument which is, say, suppose a forceps, can it capable of or sterilizing then why not something else which is just because it's written no second use, we cannot do it. This is something wrong. So this, my only humble request was that there should be some law to protect this, the hospital, and especially the implication of this, even one single item, you see the entire country, how much monetary gain we will be getting, means how much unnecessary expenses we will be saving, number one. And number two, it is also environmental friendly, because the more reuse, more single use item, we have to dispose it off somewhere which is environmental unfriendly. Thank you very much.
May I now request Dr. Rai to speak a few words, please?
And of the dais. This is the concluding session. I think it's better not to speak much on that, but still I would like to some point out, because I want to give some food for thought. I mean, how the profession is changing, medical profession, how medical profession we see today, which was about 60 years back, which was not there. Even the Lord Bernard Shaw has said, the public has lost the faith in a God, and which was transferred to the doctor. And now that faith has been lost from the doctor also, because the patient has become very intelligent. 50, 60 years back, it was not the condition. Whosoever patient coming to the doctor, whatever doctor was saying, he was taking it for granted, but not today. And Uncle Google has taught so many things to the patient. Uncle Google has given so much knowledge, even we are lacking in that way. Once the patient enters in your house, in your clinic, and he starts narrating, कि डॉक्टर साहब मैंने ये भी ले लिया, 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 अब मैं क्या करूं? And what we are left with? Either we will have to investigate it further, or then we will have to say, and I'm telling you the truth which is happening with each and every doctor sitting in this clinic. If we are sticking to the medical ethics, कि you don't require any medicines, आप जाओ ये एक बी कॉम्प्लेक्स खा लो, बाहर जाके कहता है वो, यार मैं किस डॉक्टर के पास आ गया, 1000 रुपए 500 रुपए फीस दे दी, उसको कुछ तो आता नहीं, ना तो इन्वेस्टिगेट कराया और ना कुछ किया और मेरे को उसको बाहर निकाल दिया. Have we given a thought to this thing? अगर हम उसको इन्वेस्टिगेट कराते हैं तो उसके बाद वो जाके कहता है कि जब उसकी सारी इन्वेस्टिगेशन वंस दे कम्स नॉर्मल, देन ही सेज कि वो तो कुछ नॉर्मल था, मेरी इन्वेस्टिगेशन बेकार करा दिया. So this is the dilemma which we are facing. Now you take a case of everyone, every doctor sitting in this chamber, in this hall also has experience, and we are experiencing every day. Once a patient comes in a very, very critical condition and he is shifted to the ICU, and treating at that time for the relatives, doctor is a god. See the transformation I want to say. He's a god. And after 3 days, when the patient gets settled down and he is transferred to the ward, the same god becomes a doctor. He has done his duty. यार, उनका duty था, उन्होंने किया. And after 7 days, once we give, after 7 days, once he gets a bill, same doctor becomes a dacoit. Now where we stand? Where we stand? The God three advising and requesting to the government, kindly go through the law, which whatever you have given, which is contrary to the amendments. And see everybody sitting in this hall, what is happening in the dengue case today? If the doctor has seen the patient, I'm not protecting anybody. If doctor is at the fault, he should be punished. Again, I'm using the word because from IMA we are saying this thing. But unnecessarily it's now if the hospital is not having the bed and he is giving you the proof, I don't have. He is not having the ventilator, he is giving the proof, I don't have. And he is transferring them. And now how to blame them? Your clinical establishment says that you will never say no to anybody. So okay sir, we will not say no. And by the way, if I keep the patient with me, and something happens to that patient, then also you are going to sue me? Today also you are going to sue me? Where I stand? These are the things which I want. I mean, a cool thought has to be given. These are the food for thought. We have to introspect. Again, I'm using, now time has gone when first of all a doctor has to introspect themselves also. It is a must now. And third thing which is happening very, very bad in today's time, the day this insurance company, on due respect to everyone, has come there, doctor has been pushed on the back seat. An intelligent doctor who has put 50 years of his service, nobody recognizes him. The patient comes to the hospital, gets the treatment, and he gives thanks to Oriental Insurance has given me this card here, so I was treated in the Polo ABCD hospital. And who was the doctor who was treating you? He doesn't know anything. Doctor has been pushed on the back seat. And whatever is happening in the corporate hospital or whatever is happening, it is happening only due to the doctors, not by anybody else. Hippocratic Oath was written centuries ago. My friend Dr. Ved Prakash ji is here, and we have been requesting, now I think the time has come, we should again review and rewrite that Hippocratic Oath also. Where is the patient-doctor relation? Where is the doctor and doctor relation? Because they are changing every day. They are changing every day. I mean, there is a lot I can speak on that, but only few, because the time already Vajpayee sir has hinted me also in that way to be answerable. But society has to also think doctors are also the human beings, and no doctor is going to commit any mistake or any negligence intentionally. Never, never, never in his life. And gross negligence should be punished. Our Dr. Kartikar was sitting here. He was giving one example of that, the allopathy, Ayurvedic, and this thing. What is happening in this? Cross-pathy is coming up very, very badly now. Mukhtar Chand judgment, Punjab government versus Mukhtar Chand judgment is I can say is a Gita about as far as the cross-pathy or quackery is concerned. But till today, it is not implemented in the law. So it should be corrected, sir. So it should be corrected. That's what I'm requesting, sir. We should review that.
Ultimately, state has been given the power to be permitting cross-pathy under Mukti Archana.
So there are a lot of things now. I think we have to be very, very cautious. And as far as just to avoid the litigation and others, because the patient, any patient coming inside is always, doctors are afraid of due to CP and others. So a communication is the one thing which we have to maintain. If we are very fair with the patient, lot of things in that. Very much, sir.
Dr. Kantikar, Dr. Rai, and the most important person, Mr. Vajpayee ji. First of all, I think the medical professional are real skeptical about this profession is because of three things. One is CPA, Consumer Protection Act. Second one is this CAA, Clinical Establishment Act. Third one is whether I am a professional or I am a businessman. I want to be called as a professional, but then professional has to have his fees also. He has to have his family also. And in order to, I think, has a knowledgeable things, he has to upbring his knowledge also. For that also the money is needed. But whether I have to charge or not, my learned people are here from the consumer court, they will tell me that whether I am legally protected to take my fees or not. But the way sometimes the government comes out with things which Dr. Rai pointed out recently, Delhi government comes out with his own way of thinking that this much to be charged for this particular test. I asked that our health minister that on what way you have come out to be that this should be the charge. He said you are earning so much. You are earning so much from left and right. If you are charging this much, but at least this much charge, how you have calculated this much of charge, at least has to be there. So here my lawyer friend has charges. I only know that one thing, that please calculate these charges through your own system. He is saying that we are charging, we are doing free of cost. The government is doing free of cost. So why should not you do at this much of price? But I asked him, and now I think the legal fraternity has to protect us because you are here to protect us. That's why you have taken. So all the responsibilities now lies on us, lies on you only. That how somebody can say in a government system when it the money which is incurring in those investigations? So nobody has given these kind of thoughts. And secondly, they are saying you fill up my consumer friends are there, you increase your beds. Please tell me, by increasing the bed, can I give a quality service, or even not a quality service, even an affordable, accessible quality care, which we say, can by just merely increasing bed strength, I can give that? I am not a single man clinic which I am working in a hospital, it's a teamwork. By simply increasing the bed, you cannot give services unless and until you have more doctors, you have more nurses, you have more lab technicians, you have more infrastructure into it.
The quality standards to maintain.
I said not even minimum standard to be maintained. For all these questions and to give us answers, I think only one professionals can protect us. That is a legal professionals. So we are really indebted to Mr. Vajpayee ji for coming us together and making this forum. And I wish and I pray that this forum should become more and more powerful, so that we come out with reasonable solutions which can protect the medical profession. Otherwise, this will go down. The younger generation does not want to come to this profession, but it is a need of the hour, and you have to protect the private professionals also, private doctors also, because government and Dr. Jagdish Prasad himself has said 70% of the medical treatment is provided by the private doctors. So government has failed. The private practitioners have at least brought this has brought this medical field in a respectable position, where even the world is saying that yes, in India there is some bit of medical professionals are there. So in order to protect, sir, you have to continue this hard work. Thank you very much for calling us.
Dr. Saini was the Secretary General when that Chhattisgarh case happened, where a gynecologist was imprisoned, a government doctor was imprisoned, and mind you, he was contemplating of filing cases against the government, filing a contempt petition against the government, because there were Supreme Court orders. And I and Balaji and the legal team used to visit the IMA headquarters. We, Institute of Medicine and Law, happens to be the medico-legal partner of IMA. First day there were 5 lawyers, but after he gave his viewpoints, even now you must have seen everything is to the lawyers only. All the lawyer friends left and I alone was there with him. What to do, what not to do. Thanks Dr. Saini, and again he was not at his best today. Friends, in the best of the Indian traditions, after a Mahabharat there is always a Shanti Parv. If you read Mahabharat, after the war of Mahabharat, the next chapter is Shanti Parv. In Navratris, which are going to come here, on the 8th day, there is a Durga, which is very ferocious. We do Havan and all, and after that Mahalakshmi comes in. So we had the trade unionists among doctors here. Now I'll request Dr. Ved Prakash Mishra ji to kindly deliver the keynote address. Dr. Mishra.
Honorable dignitaries on and off the dais, ladies and gentlemen, I join the learned speakers in recording my compliments and gratitude alike to Advocate Vajpayee and his entire team for really venturing in taking this notable initiative, shaping it up, diligently articulating, and the net result is before us. Having said so, ladies and gentlemen, there are certain inevitable planks which cannot be lost sight of. And if we are not in a position to take note of them intelligently and tangibly, perhaps the delay that has been caused in concretizing the situations, we will be adding to the further delay. There are three considerations which I am wanting to be putting across very candidly. Medical profession prior to Consumer Protection Act. In spite of the fact that the professional contours remain unchanged, but dimensions have altered. And it is precisely here that I am wanting to put across. It was adequate for me, ladies and gentlemen, to construe medical jurisprudence as the legal component of medicine. But it is now not sufficient for me to construe that medical jurisprudence is medical law. Permit me to say so. I am putting it across before the two learned juries. That as a medical man, I am constrained to construe that medical law is far more beyond my medical jurisprudence. And therefore, I am on a dimension where I am constrained to contemplate that there is a sense of criminal law which is applicable. There is a sense of civil law which is applicable. There is a sense of law of torts which becomes applicable to me, and also the law of confidentiality which becomes applicable to me. Why I am putting this across? The whole problem is we have not yet been in a position to tune the medical profession itself to these altered realistic considerations. There is still a hiccup. And therefore, if you really ask me, the law part and the medical professional part, how exactly they are behaving with each other, how exactly they are required to be interpolated with each other, and what exactly is expected to be the conglomerate fusion between the two is something which needs to be deciphered. Ghalib very categorically put across into these two senses of reservations. He said, "Idhar chilman se wo jhankein, udhar chilman se wo jhankein. लगा दो आग चिलमन को, न ये झांके न वो झांके." What I'm just wanting to advocate, ladies and gentlemen, please try to understand. When we were within the domain of medical jurisprudence, there were only two cardinal considerations which governed and guided the profession. The paternalistic part of the medical profession cannot die. And that's the constant factor which was, which is, and it shall pervade. The day the paternalistic component of the medical profession will be eroded, take it from me, medical profession will decay, degenerate and die. But then, can paternalistic concept in the medical profession remain unbridled? Should it be construed as absolute? Should it be taken as sacrosanct? The answer is a big no. And therefore, the balancing of that paternalistic approach inbuilt in the medical profession has to be interpolated against with the concept of informed consent. And this is the balance. We have not been able to hold the balance properly, and this is the $1,000,000 question which I am wanting to put across. We still believe our considerations are paramount. हमारी मानवता के अंदाज इतने प्रखर हैं कि उसके अंतर्गत इन्फॉर्म कंसेंट लिया या नहीं लिया आपने सुना. हमारी निष्ठा इतनी पक्की है कि इन्फॉर्म कंसेंट की क्या जरूरत है. ये नहीं चलेगा, ये नहीं चल सकता. और इसलिए मैं आपको बुनियादी तौर के ऊपर मैं आपका ध्यान आकर्षित करना चाहता हूं कि दो दूरस्थ कोने जो एक दूसरे के विपरीत दिख पड़ते हैं, वे एक दूसरे के विपरीत नहीं हैं. चेक्स एंड बैलेंसेस प्रोफेशनल इंट्रिंसिक कनोटेशंस के साथ में जुड़े हुए हिस्से हैं, और उनको केवल स्वीकार नहीं करना पड़ता, उनको आत्मसात करना पड़ता है. और उनको आत्मसात करने के साथ उन सारी विधाओं को किस तरीके से दैनंदिन जीवन के अंतर्गत अमल में लाया जाए, यह आवश्यक है. Speaking for on behalf of the Medical Council of India, there are wanton gaps. I have no hesitation in putting across. But believe me, ladies and gentlemen, the entire gamut of legal frame Should it not be a integral part of the curriculum for a student and a learner to be oriented on? You talk of first contact physician. You talk of the MBBS degree holder, primary registering qualification, and we have still not been in a position. We still are in the domain of talking only code of medical ethics as far as the understanding of his law is concerned. Medical council and for that matter professional associations believe that code of medical ethics and etiquette perhaps is the first law and the last law which the medical graduate is expected to be knowing. The answer is a big no. It is only a part of the normative legislation that is under the jurisdiction of Medical Council of India. But beyond that self-code, beyond that code of medical ethics, there are vast areas of the laws or medical laws, the tenets of which govern the medical profession in and out, of which he is ignorant. Therefore, if you really ask me, what exactly, Dr. Bajpayee, you are wanting to be bringing across? The level of ignorance on part of the doctor community, on part of the professional community in regard to the tenets and governing laws. And permit me to say so, please don't misunderstand me. Ignorance and arrogance, they go hand in hand. More the man is ignorant, more he is arrogant, and he thinks that his ignorance itself is an asset for him. Time has come, ladies and gentlemen, when we are required to be taking the realities in the stride as it ought to. And it is here your initiative is worthy. There are two other important considerations which I am wanting to be putting across. And that is, there has to be a structured orientation. You are talking about the update of the knowledge of the professional. You are talking of the update of affective domain of the professional, the behavior and attitude of the professional. We are contemplating his update in the domain of skills. Why it should not be updated on the contours of laws? Why it should not be updated on the terms of the various propositions which are emanating in terms of various interpretative dimensions? Who is making us aware? Why should not only just incorporation of the structured format of the laws governing medical profession to be inbuilt into the curriculum at all levels, should it not be a part of the continuing medical education in the domain of that update? Why should we not contemplate that the credit points that we gain in the domain of continuing medical education, there should be an assigned credit allocation for the purposes of ensuring that the professionals are updated in the various domain of law, then only their revision of the registration is expected to take place. You have to evolve ways. You have to evolve means. You have to evolve structured mechanism. You and me will not be in a position to be just continuing playing the blame game. इनके कारण हुआ, उनके कारण हुआ, ये हमारी नक्शाकद में नहीं समझ पाए, वो हमारी महत्ता नहीं समझ पाए, ये हमारा प्रतिपादन नहीं समझ पाए. दुनिया ना समझ नहीं है. हम कहीं न कहीं नासमझी की गिरफ्तारी में हैं. And therefore it is the level of awareness. Just as we talk of clinical competence, just as we talk of technological competence, just as we talk of cognitive competence, just as we talk of cognitive competence, just we talk of psychomotor competence, should we not talk of legal awareness competence? You and me have to be legally aware. You take a random survey, leave aside the duration of records, the modality of maintenance of records, the authentication of records, the manner in which the records are expected to be put across. Absolutely, who teaches them all? Where exactly is that knowledge? How exactly that orientation is required to come? And therefore, only to say that people are required to be prescribing guidelines and we will be in a position to follow is one part of it. But entire what we call is, there is a word which is used in our mythology and in our community life, and that is sanskar. Awareness of these propositions, they are expected to be a part of the professional sanskar to be dispensed of. And therefore, there has to be a formal and there has to be informal methodology in this entire connotation. This white paper, ladies and gentlemen, believe me, whatever, no words will be in a position to really go in for the appreciation of the same. I am here not only to be just putting across my views. I am here representing an organization as the chairman of the Academic Council of the Medical Council of India. I owe my responsibility and accountability. I have read this entire book carefully, diligently, and I have jotted down. There are responsibilities which have been listed for the Medical Council of India in this white paper, A, on page number 4 for me. The carry home message I am carrying. Another responsibility which has been put on page number 6 of this white paper. Another responsibility which has been put on page number 22, page number 28, and page number 29. These are the 5 pages on which Diligent accountabilities have been incorporated, and I am therefore here not to preach. I am here to commit the initiative which has been undertaken by you. To me, it is no less than an entire याज्ञिक प्रपोजिशन जिसे मैं कहता हूं. यज्ञ का यजमान कौन है यह महत्वपूर्ण नहीं है. यज्ञ का पुरोहित कौन है यह महत्वपूर्ण नहीं है. यज्ञ की यज्ञाग्नि कहां से आई यह महत्वपूर्ण नहीं है. पर इस यज्ञ के लिए संविधा की लकड़ियां कहां से आवेंगी वो महत्वपूर्ण है. इस यज्ञ की संविधा की लकड़ी बनने का संकल्प इन 5 कागजों के, इन 5 पन्नों के ऊपर में लिखी हुई वे आह्वानों के स्वर, उनको प्रतिबद्धता के साथ कैरी होम मैसेज के तौर पर ले जाना और निश्चित तौर पर इन ए टाइम बाउंड मैनर उन सारी चीजों के इनिशिएशन को करके प्रतिपादित करने का प्रामाणिक प्रयास करना. इस संकल्प के लिए मैं आपके बीच उपस्थित हुआ. अपनी अपनी जिम्मेदारियों के एहसास लेकर के अगर हम उन वस्तु स्थितियों के निराकरण के प्रति प्रतिबद्धित होकर के कार्यशैली में रत होंगे, मेरा दावा है हमें किसी को दोष देने का कारण नहीं होगा. Collectively, cumulatively, by discussion, by debate, by deliberation, by articulation, understanding and capable of generating a consensus. कई चीजें इस consensus के अंदर में जो कदाचित हमारे जहन में थीं, but we were never in a position to bring it out. Today this document is cataloging as to which are the gray areas. Confluence of the gray areas has been indicated in this white paper, and therefore even for initiation of an action, there has to be a ground material for the purposes of contemplating that action. That action plan has to be viewed against the challenges and concerns. Who exactly is to compile? We feel and perceive the challenges, but they are not concise and they are not put across onto a common plank. And therefore, believe me, this white paper which has been generated on 6 distinct areas and the grey areas which have been so vividly brought into it, diligent application of mind by all concerned, not only in isolation, but in unison, in interaction. I am so grateful to the 2 learned members of the commission present over here. Definitely I undertake, promising is a bad word, I undertake that there should be periodic interactive discussions wherein the informational planks, the operational planks, the interpretative planks, the requirements, the deficiencies, they can be taken note of and planned and diligent efforts can compensate for the same. Ladies and gentlemen, putting across that these are the gaps and counting them and then escaping ourselves in the name of a discount is not going to sort out the problem. We have to take the onuses. We have to take the responsibilities. We have to take the roles. We have to identify the challenges and then we have to put across our individual responsibilities jointly and severally for taking them to proper stride and tackling them in the most diligent manner. Let us resolve. We can make it, and that's exactly what I am wanting to put across. It can be undertaken. It can be done. But yes, vigilance is expected to be the hallmark and creative contribution is expected to be the path. Let us take that onus. Let us take that responsibility. And therefore, if you really ask me what I am wanting to be putting across in the keynote addresses, it's not enough to find that the mechanisms are locked. But it is true that instead of searching a master key, we become a small time key for a small time lock so that a large time proposition gets unlocked. And it is that mechanism, ladies and gentlemen, which in my humble opinion is the hallmark which has been generated by the team led by Dr. Bajpai and his entire team. Only patting their backs is not going to suffice. Let us render our shoulders to them and we will be in a position to be evolving a change. If you really want me to conclude what I'm wanting to say, I'm just wanting to say. Coming from a small place like Nagpur, where Wardha and Sevagram is adjacent, a small dictum is put across in Sevagram Ashram. Mahatma Gandhi said, who does not want to see a change? But if you want to see a change, please try to be the change what you want to see for yourself. Let us be the change, and I assure we will be able to see the change. It's with this humble submission, with a sense of profound gratitude and thankfulness to Professor Bajpai and his entire team, I am saying thank you very much for taking up this responsibility. We shall not let you down, and we shall render our shoulders for this noble cause. Thank you very much.
I would thanks Dr. Mishra for that wonderful keynote address. Now I'll request Mr. Ravindra Mangal to please give the vote of thanks.
Thank you, Dr. Mishra, for your kind, encouraging, and positive messages. I'm sure all these people here are here only for the reason that they would like to see and bring some change. They have put in a lot of time, they have put in a lot of efforts. I see change happening very soon. Thank you, everybody. On behalf of the Institute of Medicine and Law, I take this opportunity to offer my heartfelt gratitude to everybody who's present in this room, on and off the dais, maybe some more who have not been able to make it today due to some reasons, but it is because of your support that we have been able to reach here. Thank you very much.